Another day, another court story, and we are going to be talking about it right now. So let's get into it. Okay, my name is John Crump, and I'm a journalist, and I am joined by my fellow co-host, Flying Rich, who is a professional co-host, apparently, because he's co-host everyone's show. But he won't start his own, even though we keep on telling him to start his own. But
maybe I'll start one tonight.
There you go. There you go. You're going to start a podcast tonight or something like that. Okay, today we are going to be talking about the latest in the California versus the 3D printing guys. But first, my 50th birthday is coming up, and if you want to give a super chat to go to a birthday present for me, you can, and it's all because of some jerk.
First off, I don't believe you're 50.
Yeah, I turned 50 on Monday. And wow. If we do get whatever, I'll do like a live stream on my birthday or whatever. But yeah, so this is all because of some jerk, by the way.
Yep.
Rich knows what I'm talking about.
That's funny.
How do you like that? Okay. Today we're going to be talking about CTRLPEW LLC and Alexander Holiday versus David Chiu in his official capacity as San Francisco City Attorney, and Rob Bonta in his official capacity as AG of California. This is a response to the California lawsuit against these guys. Which
can I stop you for a moment?
Not yet. I believe that it violates the First Amendment. Tax Sub, did you see my message? Just let me know. But yeah, so let's go ahead and we're gonna get right into it. I'm not gonna waste too much time. It is a short complaint. Stimbolia did something earlier on it, and I decided to wait a little bit because I didn't want to, because he did a really good breakdown of it.
So there's one part in here that is quintessential Matt LaRossiere, and I'm wondering if you're gonna find it.
Yeah, I already know. So let's just go and read through it. Rich?
Yeah, you.
Let's go.
Oh, you got to put it on the screen.
It's on the screen.
Not my screen.
Can you guys see it out there?
I see me. I see you.
Can you guys see the document out there?
It's weird. I hover over it. It says remove.
They can see it.
Hold on. I'm going to refresh.
All right, I'll start reading it. This pre-enforcement civil rights action under 42 U.S.C. Section 1983 and the Declaratory Judgment Act, 28 U.S.C. Sections 2201 through 2202, seeking declaratory and prospective injunction relief to prevent the extraterritorial application of California Civil Code Section 3273.61 and 3273.625 to the plaintiff's protected speech and lawful conduct occurring wholly in Florida.
I'm in, so.
Do you see it?
Yeah.
All right, go ahead.
Plaintiffs are Florida residents who publish and link to written guides, photographs, and digital design files on the internet. Defendants, California's Attorney General and San Francisco City Attorney, have announced and initiated a civil enforcement campaign that expressly targets plaintiffs' Florida-based speech and threatens civil and criminal penalties based on California's effort to regulate and suppress speech occurring in Florida merely because it may have been accessible in California. Plaintiffs have been forced to self-censor and cease registering copyrights for his work as a result.
Okay, let me explain that. When you register a copyright, it goes into the Library of Congress, which can be accessed from anywhere.
Even California?
Even California, anywhere. there's no blocks on it, and there would never be any blocks on anything.
Are you saying firearm manufacturers might patent their firearms, and then you could find those patents in the Copyright Office and then download the schematics and build them in California?
Yes. So that's what they're talking about there. But let's go ahead. There's a bunch of jurisdictional stuff. Well, let's just read through it. It's not that long. Usually we'll skip this, but let's go ahead.
Jurisdiction and venue. This court has subject matter jurisdiction under 28 USC 1331 and 1343 because this action arises under the Constitution and laws of the United States, including 42 USC 1983. This court has authority to grant declaratory relief under 28 USC 2201 and 2202, and prospective injunctive relief under court's equitable powers. Plaintiffs also seek attorney's fees and costs under 42 USC 1988. Personal jurisdiction is proper because defendants have purposefully directed an enforcement campaign at identified Florida residents and Florida-based publication activity by filing a civil enforcement complaint that names plaintiffs and seeks to impose civil penalties and injunctive relief on plaintiffs for purely Floridian speech and links published on the open internet, publicly announcing that enforcement action and characterizing plaintiffs' Florida publication activity as unlawful and thereby causing and intending to cause the brunt of the constitutional injury, plaintiffs' chilled speech and self-censorship to be felt in Florida. And that's a case Calder v. Jones, Defense Distributed v. Grewal, and
that's out of New Jersey. Well, I think it's interesting that they cited that case since I think today they're going against the
not buddies.
And well, I think there is a hearing today on suppression of evidence, or destruction of evidence in Florida for the rocket log chats and Galilog versus Defense Distributed. But
and they cite another case, Media Matters for America versus Paxton. Venue is proper in this district under 28 USC 1391 B2 because a substantial part of the events and omissions grieving rise to plaintiffs' claims occurred in this district, including plaintiffs' publication activities and the resulting chilling and self-censorship in Orlando, Florida. Parties. Plaintiff, CTRLPEW LLC, is a Florida limited liability company with its principal place of business in Orlando, Florida. Plaintiff, I'm not going to say his name, Alex, is...
Yeah, I don't think Alex, I don't think he really hides his name.
Okay. My buddy Alex is a natural person domiciled in Orlando, Florida. Defendant, Rob Bonta, is the Attorney General of the state of California and is sued in his official capacity for prospective declaratory injunctive relief ex parte Young 209 U.S. 123, 1908. Defendant David Chiu is the city attorney for the city and county of San Francisco and is sued in his official capacity for prospective declaratory and injunctive relief.
You know what San Francisco is known for?
Rice-A-Roni?
People crapping on the streets. Keep on going.
I was going to say 4 other things, but that's the most G-rated one that came to mind. Factual allegations. Plaintiffs operate and maintain a Florida-based website, CTRLPEW.com, through which they link to written guides, photographs, and digital design files, including 3D models, that are expressive works and technical instructions. Plaintiffs' website primarily links to a third-party hosting platform, Odyssey, where some of those works are made available. Plaintiff speech is created in and posted from Florida and are not directed to any particular state.
All right, that's really important there. I just want to get this off. My birthday's on Monday, not today, but just I'm doing this because I'm a jerk.
Do I have to send you a super chat?
Yeah, well, I'm about to send Terry something for her fundraising.
Oh, thanks.
I just haven't got a chance to do it yet.
That's
But
kind.
this is interesting because it also highlights that the files aren't actually on CTRLPEW.com. They're on Odyssey, which is a third-party website. So they should have some protections anyway. But yeah.
Yeah, there's a couple of problems with that. One, they're not making people in California print guns.
And they're not advertising towards California either.
And they're not sending the files to people in California.
Yeah.
Okay. Plaintiffs do not specifically target California users, do not direct advertising towards California, and do not maintain offices in California. Plaintiffs do not travel to California and have no intention of ever doing so. Plaintiff Holiday has not been to California since 2008 and specifically desires never to set foot there again.
Yeah, I like that.
Let's see. On February 6, 2026, defendants filed a civil enforcement action in the Superior Court of California, County San Francisco, captioned "The People of the State of California v. Catalog Foundation, Inc. et al. Seeking permanent injunction, civil penalties, and equitable relief under California Civil Code BS and California's unfair competition law. Plaintiffs Holiday and CTRLPEW LLC are named defendants in this action, attached as Exhibit 1. Defendants' California complaint expressly alleges that plaintiffs are unlawfully distributing and promoting downloadable digital code and instructions and seeks to suppress plaintiff speech by court order in monetary penalties up to, is that $7.8 million?
Yeah, over $7.9 million. But I do want to point out something et al. Some people emailed me, but first, thank you, Anthony Mister, for the $2. I'm going to be doing this fundraiser through Monday. Then I'm going to buy myself something nice, and then donate probably the same amount of money to charity. But or we just might do that totally. But the whole thing is
a joke.
It's a joke. But yeah, I appreciate anything. Yeah. So et al, a lot of people have been asking me, what the hell is et al? I see that everywhere. That just means that there's other people listed. It's like etc. What's up with other people. And in this case, it would be Ivan the Troll. It would be Fudbusters. It would be the 100 other anonymous people that they cited as well.
Mm-hmm.
So yeah, that's all that means.
Defendant's California complaint alleges that plaintiff's conduct violates California Civil Code 3.2, I'm not going to say BS, which purports to prohibit a person from knowingly distributing computer code for use in 3D printing of a firearm precursor part, a firearm receiver, a firearm-related product, a prohibited firearm accessory. 21. Defendants' California complaint underscores the criminal law implications of defendants' threatened enforcement by citing California Penal Code provisions in its footnotes, including footnotes 3 and 16, citing Penal Code 29010 and 30515. Plaintiff Holiday fears that defendants' civil enforcement actions are designed to drag plaintiff into a foreign jurisdiction where he may be subject to arrest in California for his Florida conduct, which was entirely lawful in Florida.
I mean, and that is a concern, and that's a legit concern.
Let Hugo Chavez know about this also. Defendants amplified these accusations through public press release announcing the lawsuit and describing the plaintiff's Florida-based publication as unlawful. These statements and citations reinforce plaintiffs' reasonable fear that defendants will use California coercive process to punish or suppress plaintiff's Floridian speech.
Which is exactly what they're doing.
Defendants announced the enforcement action publicly through an Attorney General press release dated February 6, 2026, describing the lawsuit as a landmark effort and asserting that the plaintiff's publications are unlawful. Defendants' filing and public statements have forced plaintiffs to self-censor. In particular, Holiday has refrained from publishing additional works and has paused planned publication activity on and through plaintiff's website for fear that California will seek civil and criminal penalties or injunctive relief based on Florida origin speech that is accessible in California. Plaintiff has registered many of the guides, photographs, models, and instructional materials he owns with the United States Copyright Office.
Which means they're in the Library of Congress, which means they're available in California.
So California would have to sue the Library of Congress also, because people could access them through the Library of Congress. Plaintiff fears that because the deposit copies of such works could be obtained by a California resident from the Library of Congress or from the Copyright Office itself, plaintiff will be unable to register any additional copyrights with the United States Copyright Office. As a result, plaintiff has been forced to cease registering his works with the United States Copyright Office. Because plaintiff fears he is unable to register his work, plaintiff loses out on his effective registration dates in the relevant works with each passing day. Because plaintiff would lose the benefit of registration, plaintiff has been forced to elect not to publish additional works. Because plaintiff fears he is unable to register his works, plaintiff is unable to enforce the copyrights relevant to his works.
This is another thing. The number 32 is something that is also very interesting.
Plaintiff is unable to enforce the copyrights, which he currently has registered, as doing so would involve filing exhibits which would be available through PACER to Californians, and thus subject the plaintiff to further harm from defendants.
Yeah, so anyone who has a PACER account would be able to download it, or someone access it with the Court Listener plugin on their computer. It would automatically get uploaded to Court Listener, and then people would be able to access it through Court Listener too, which technically would violate California law because California is trying to make speech illegal.
This 32 is what I consider the most Matt LaRossiere of this statement. It's like, I could attach it, but then I'd be illegal.
Yeah, so keep on going.
33. Plaintiff wishes to attach examples of some of his works as exhibits to this complaint, but cannot, as they would subject him to further harm from defendants.
No, I mean, maybe they can do it like, say, hey, well, we want it sealed. I don't know.
Defendants have not served plaintiffs with process in the California action as the filing of this complaint. Nevertheless, the California complaint, the press release, and the defendant's stated enforcement posture create a credible and immediate threat of enforcement sufficient to chill plaintiff's speech as established in Article 3 case or controversy, Susan B. Anthony v. Dryhouse? I'm not familiar with that.
Yeah, I actually referenced it in an article yesterday.
Oh, okay. This action does not seek to enjoin, stay, or interfere with proceedings in California state court. Plaintiffs seek only declaratory and prospective injunctive relief, preventing defendants from applying California Civil Code 327361 and 327365 to plaintiff's speech and publication activities undertaken wholly in Florida. Plaintiffs' guides, photographs, instructional materials, and digital design files constitute expression protected by the First Amendment. Courts have recognized that technical information and computer source code are speech for First Amendment purposes. And I believe that's Ninth Circuit. Yes, it says Ninth Circuit Court.
Yeah, Ninth Circuit, which is where California is. Florida is in the 11th Circuit.
Claims for relief. Let's see. Against Bonta and Chiu, plaintiffs incorporate paragraphs 1 through 36 as if fully set forth herein. Defendants acting under color of state law have initiated and threatened enforcement under California Civil Code 327361 and 327365 to suppress and penalize plaintiffs' protective speech published from Florida on open internet. As applied to the plaintiff's Florida-based speech, the challenged enforcement functions as an unconstitutional prior restraint and content-based restriction is not narrowly tailored to any compelling governmental interest and has caused plaintiffs ongoing and irreparable injury through forcing self-censorship and preventing registration of its works with the United States Copyright Office. Plaintiffs are entitled to declaratory and prospective injunctive relief, barring defendants from enforcing the challenge provisions against plaintiffs based on speech and publication activities undertaken wholly in Florida. Count 2. So 42 U.S.C. 1983 14th Amendment due process extraterritorial enforcement against Bonta and Chiu. Plaintiffs reallege and incorporate by reference paragraphs 1 through 36 as if fully set forth herein. The Due Process Clause limits states' authority to impose its law extraterritorially on persons with insufficient context to the state and to punish or enjoin conduct that occurs wholly outside the state's borders.
What California is going to say here is California is going to try to make an argument that since the files are available in California through the internet, that's interstate commerce. That's just what they're going to say.
But if they're looking for them to prevent this, shouldn't the California government have a firewall preventing things coming in?
Great Firewall of China.
Or maybe the ISP is just as liable.
No, the ISPs, they're actually exempted by federal law.
43 defendants threatened enforcement against plaintiffs for Florida-based speech activity violates these limits. Defendants attempt to apply California Civil Code 32761 and 327625 to plaintiffs' Florida speech also deprives plaintiffs of fair notice and invites arbitrary enforcement because it conditions civil liability on the downstream acts of third parties and on the mere accessibility of speech in California. Plaintiffs are entitled to declaratory and prospective injunctive relief, barring defendants from enforcing the challenge provisions against plaintiffs based on speech and publication activities undertaken wholly in Florida. Count 3, declaratory relief, dormant commerce clause, extraterritorial regulation against Bonta and Chiu. 46, plaintiffs reallege and incorporate by reference paragraphs 1 through 36 as if fully set forth herein. As applied to plaintiffs' Florida-based publication and linking on the internet, California Civil Code 32761 and 3273625 operate as impermissible extraterritorial regulation by controlling conduct and speech occurring wholly outside California and by projecting California policy choices onto the national internet. An actual controversy exists between plaintiffs and defendants concerning the constitutionality of defendants' threatened enforcement as applied to plaintiffs' Florida-based speech, and plaintiffs are entitled to a declaration of their rights and defendants' obligations. Count 4. 42 U.S.C. 1983. All right, 49. Plaintiffs reallege and incorporate by reference paragraphs 1 through 36 as if fully set forth herein. 50. Plaintiffs' publication and technical instructions relate to the design and lawful manufacture of arms and arm components and facilitate the exercise of plaintiffs and others' right to keep and bear arms by seeking to suppress and penalize plaintiffs' Florida-based publication through extraterritorial enforcement. Defendants burden conduct protected by the Second Amendment. Plaintiffs are entitled to declaratory and prospective injunctive relief, preventing defendants from enforcing California Civil Code 3273661 and 3273625 against plaintiffs in Florida based on plaintiffs' Florida-based speech. 53, prayer for relief. Plaintiffs respectfully praise the Honorable Court, declare that defendants threatened and ongoing enforcement of California Civil Code 327361 and 3273.625 against plaintiff speech activities undertaken wholly in Florida violates the First and 14th Amendments of the United States Constitution, declare that the defendants may not apply California Civil Code 327361 and 3273.625 extraterritorially to regulate plaintiffs' Florida-based speech and publications on the internet, primarily and permanently enjoin defendants and their officers, agents, employees, and all persons acting in concert with them from enforcing California Civil Code 327361 and 3273.625 against plaintiffs based on plaintiff speech and publication activities undertaken wholly in Florida. Award plaintiffs cost and reasonable attorney fees under 42 U.S.C. 1988 and grant such other and further relief as the court deems just and proper. Dated February 11th. Matthew Larossier.
I think it's Larossier.
Okay.
I don't know.
Can we call him and ask?
I don't know. Something that I've always wondered. Everyone says Larossier, and I think it's Larossier, but I'm not sure.
Is that like Stimbolier or Stimbolia?
Yeah, basically Stimbolia is how you say it, Stimbolia. But one of the things that I wanted to bring up here, and this might be a little bit of a controversial take, is when states started passing like age verification laws for certain websites. I was like, I don't think that. I was like, I don't think this is constitutional, and I think this could get a bad, this could be bad because it could be applied to other stuff, and a lot of people are like, oh, why are you just trying to defend that type of website? I'm like, because it's it is what it is. It's a violation of the First Amendment, and even if I'm not into that type of content,
well, I mean that's like the Larry. What's the guy's name from Hustler? Larry Flint. Thank you. It's like, while I may find what he does abhorrent, disgusting, whatever, it's the speech that needs to be protected, as in the trope that everybody uses when they talk about free speech and First Amendment, is the only speech that needs to be protected is the speech you disagree with.
Correct.
So I gotta hand it to Matt. I was very impressed with this brief. I thought it was some of his best work ever.
Yeah. I like that. It's good how he did that.
And I at first thought, wow, Matt's screwed, because the process is the punishment. But this
the punishment. Let's be honest.
But this is a really substantial, I think, well thought out and very intelligent response.
Yeah, it's a good strategy. I would have to agree with that, because in California, it's going to be nearly impossible to win.
Yeah, and I've heard other lawyers. It's like, why would you fight them in that arena? Like in other cases based on venue issues, it's like, yeah, don't fight them in that arena. So Matt and anybody else named in the California press release have not been served yet.
No.
So, I mean, other than PR, like, what should they expect to have physical service of a summons?
Yeah, they're gonna get it. I mean, they're definitely gonna get it. Physical. Sorry, let me just do a case search here. Give me 1 second here. I'm gonna just see if there's anything new. No, I already checked that. There's nothing. There's
really?
some stuff today, but like nothing like it was like minutes and stuff like that. So, what I'm gonna do is I'm going to see if there's if they've added anything to the docket or anything like that. for this case.
Meaning California, or
Yeah.
Hmm.
Yeah. So just bear with me here.
Because I gotta say, I know Matt was pretty upset because both it named him CTRLPEW, Ivan the Troll. So these people were looking at a substantial financial hit if California was successful, and there's no reason to think that California wouldn't rubber stamp this because it's their attorney general and their county attorneys making these complaints. So, some areas, I hate to say it, I would, if I was a judge, I would be legally bound to follow the law regardless of what my opinion was on it. And
Yeah, I mean,
even if I disagreed with it, I'd be like, that's the law. Second Amendment's the law. The 14th Amendment applies all of these laws to the states. You have the right to keep and bear arms, which includes building firearms. There's a number of things, even the speech issues. So this is a First, Second, and 14th Amendment issue. The idea that if displaying a 50 BMG is illegal in California, because actually 50 BMGs are illegal in California, and somebody from California watches this video, can they send me a summons?
I mean, well, the UK wanted to extradite people, right?
Oh yeah. They were saying, like, if we don't like your social media speech, if you have hate speech on social media, they'll come after you.
We're going to it was ridiculous, but whatever.
Yeah, and I gotta say, I could not be an activist judge. I absolutely could not. I love that people like Crump, Dark, and myself are considered radicals because we believe in the Constitution as it was written.
It's amazing how that is, right?
You're a radical if you deny these things and actively work against them. That's the definition of what a radical is.
Yeah, it's amazing how that works, right?
And I love to say I am liberal with my application of the Second Amendment.
Yeah, it's amazing how they try to do shit like that.
Indeed.
But yeah, I don't see anything right now. But who knows? It's one of those things that they have. One of the interesting things that I find interesting is this. I just want to share this because this is something. This is what we're fighting against, and this is what I want to share. This is a headline out of California.
California sues over ghost gun manufacturer. I see no ghost guns there.
And they're not ghost gun manufacturers either. You see what I'm saying?
You mean those serialized firearms?
No, they don't sell ghost guns. The article made it sound like they were selling ghost guns.
Right.
So it's definitely interesting how they try to frame it. It's just wrong. It really is wrong, but who knows? We're gonna have to see exactly what happened in this case, but I like the fact that they're fighting back. I think it's good.
And I think they have a compelling argument that the court should favor them, especially a Florida court.
Yeah, I think it's perfect that they said, "Hey, you know, we're not in California. We have no intention of going to California."
But this is another thing. I'm just surprised that this case has not gotten wider appeal for the First Amendment aspects of it. That I would think, you know, the New York Times would have issue with this case.
Yeah, it's going to be interesting to see, but you know, I don't know. It's like they are fighting against free speech in California. They don't want free speech. They want to control people. They want to control everything that people do. And they're for free speech as long as the free speech that you're speaking is
what they agree with.
They agree with.
Mm-hmm.
Now, if you don't, then they don't agree with you. But yeah, we're gonna get out of here though. We got a show coming up at about an hour. We're gonna be doing a case wrap up because there's been some other interesting developments in places like the Fourth Circuit and some other cases. Though we'll go ahead and talk about those tonight. Just a lot is going on right now.
Yep.
And we're out of here. Thank you guys. Bye bye.